Establishing a valid marriage in England and Wales requires meeting two specific legal pillars. First, each party must have the legal capacity to marry. Second, the couple must strictly comply with the state's required formalities. While capacity rules apply to everyone equally, the required formalities are fractured into different statutory frameworks based on the type of ceremony chosen. There are 4 recognized pathways to form a marriage. 3 are standard: civil, Church of England, and non-Anglican religious ceremonies. These 3 are bound by standard statutory constraints. The 4th pathway is reserved specifically for the Quakers and those of the Jewish faith. The Marriage Acts carve out a specific historical exemption for this category, fundamentally changing how the ceremony itself is regulated. To properly advise clients on the validity of these relationships, practitioners must understand exactly where civil law mandates compliance and where religious usage takes over. Most non-Anglican religious ceremonies, such as Islamic or Hindu marriages, begin with a baseline physical requirement. By law, these standard religious marriages must occur within a building that is specifically registered as a place of public religious worship. Quaker and Jewish ceremonies are exempt from these venue constraints. The state permits these marriages to be solemnized wherever the parties choose, provided they follow their own internal rules and usages. These religious usages have historically operated independently of the state's mandated ceremony formats. Because of this autonomy, no state-authorized wording is required during the solemnization, and no civil registrar needs to be present. The law grants these two faiths a unique zone of autonomy during the ceremony itself, but that freedom is strictly conditional. Every religious ceremony in this category is anchored back into English civil law by a mandatory set of civil preliminaries. Both parties must give a formal notice of marriage at the district registry office where they reside. Giving notice starts a statutory clock. This notice triggers a mandatory 28-day waiting period, allowing the state to investigate potential impediments or immigration abuses. Only after this period has passed can the registrar formally issue a certificate, legally authorizing the ceremony to proceed. The legal integrity of these marriages depends entirely on securing this civil foundation before the religious rites can be exercised. This raises a critical question for litigation. What happens if these civil preliminaries are knowingly and willfully ignored? If the notice phase is bypassed, the ceremony enters the failure pathway. While minor procedural flaws might only lead to a void marriage, a total failure to engage with the Marriage Act 1949 drops the event into a different legal classification. The law classifies such an event as a non-qualifying ceremony. Case law treats a non-qualifying ceremony not as a defective marriage, but as an event that is legally non-existent. This leads to a catastrophic practical consequence. The parties have no standing to apply for financial remedies or property orders under the Matrimonial Causes Act. Without civil preliminaries, the religious ceremony is legally meaningless, leaving both parties with 0 statutory protections if they separate. The interplay between civil and religious law also dictates how these marriages are dissolved. When a civilly recognized religious marriage breaks down, there is a complex jurisdictional overlap. A party might be granted a civil divorce, but remain bound under religious law if their former spouse refuses to cooperate. This is often called a limping marriage. In the Jewish faith, the religious dissolution is known as the get. It requires mutual cooperation before a religious tribunal, the Beth Gen. To solve this impasse, Parliament created Section 10A of the Matrimonial Causes Act 1973. Section 10A empowers the civil court to withhold a final order of civil divorce until evidence is provided that the religious get has been obtained. This protects individuals from being trapped between a finalized civil dissolution and an unresolved religious bond. The legal architecture of Quaker and Jewish marriages creates a structural division in English family law. At the preliminary stage, the state is absolute. Notice and waiting periods are mandatory. In contrast, the ceremony itself is a zone of religious autonomy. Finally, the civil court maintains protective oversight during the dissolution stage. Advising these clients requires mapping exactly where the civil law mandates compliance and where it allows religious usage. By identifying these boundaries, practitioners can determine whether a binding legal marriage was ever formed.